The Supreme Court of the United States just rewrote the rules on 14 different gun laws, and the mainstream media didn't say a word. Not a headline, not a segment, not a single network anchor looked into the camera and told you that the legal ground beneath your feet as a gun owner shifted dramatically. That's not an accident. That's a choice. And while they were busy covering everything else, millions of law-abiding Americans were left completely in the dark about a ruling that could make them criminals or set them free. This is a Wilson decision. This is the biggest transformation to gun law in America since the Bruen ruling back in 2022, and you deserve to know every single word of it. My name is David Hookstead, and this channel exists for exactly this moment. Because when the institutions that are supposed to inform you go silent, somebody has to speak. 14 changes. Some of them protect rights you didn't even know you had. Some of them expose violations you didn't know you were committing. All of them matter, and all of them are already in effect right now. Before we go any further, if you're not subscribed to this channel, fix that right now. Hit the subscribe button and turn on notifications, because this is exactly the kind of story that never makes it to your television, never trends on social media, and never gets covered by the outlets that are supposed to be doing their jobs. This channel is your early warning system. It only works if you're part of it. Subscribe now and stay with me, because what comes next could change everything about how you own, carry, and store your firearms. Let's start at the beginning, with a man named James Wilson, a law-abiding gun owner from Pennsylvania, who got arrested for having a rifle with a barrel that measured 15.9 inches. Federal law says rifle barrels must be at least 16 inches, or the firearm is classified as a short-barreled rifle under the National Firearms Act, which requires special registration, a tax stamp, and federal approval. Wilson wasn't a criminal. He wasn't a threat. He was a gun owner who trusted that the government enforcing the law against him had a clear, consistent standard for measuring it. He was wrong. And when his attorneys dug into it, what they found was damning. The ATF, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, didn't have a single consistent method for measuring barrel length. Sometimes agents measured from one point, sometimes from another. Sometimes they included the muzzle device. Sometimes they didn't. The standard changed depending on the agent, the case, the day of the week. Wilson argued that this inconsistency was not just sloppy, it was unconstitutional. And the Supreme Court of the United States agreed with him. But here's where it gets extraordinary. The court didn't just rule on barrel measurements. They didn't just fix one narrow technical issue and move on. They looked at what Wilson's case revealed about the ATF's enforcement culture, and they asked a much bigger question. If one enforcement standard is arbitrary and inconsistent, what does that tell us about the others? The answer they came to should alarm every American who believes in the rule of law. They identified 14 separate federal gun regulations that suffer from the same foundational problem: vague, inconsistently applied standards that give government agents enormous discretionary power over ordinary citizens. 14. That's not a minor procedural correction. That's a structural indictment of how gun law enforcement has operated in this country for decades. The first major change out of that ruling hits concealed carry permit holders and people who want to be concealed carry permit holders directly and immediately. For years, certain states operated under what's called a may-issue framework. For concealed carry, under that system, local officials, sometimes a sheriff, sometimes a licensing board, could deny your application for a carry permit if they decided, in their subjective judgment, that you didn't have a good enough reason to carry a firearm. They used terms like suitable cause or proper cause as the standard. Sounds reasonable on the surface, right? Except that standard was never defined. It meant whatever the person reviewing your application decided it meant. In practice, it meant wealthy, connected applicants got permits. Regular people got denied. The court has now said that is over. States and the federal government cannot use vague, subjective terms to gatekeep who gets to exercise a constitutional right. The standard for issuing a concealed carry permit must now be objective and transparent. If you pass a background check, if you complete any required training, if you meet the clearly defined criteria, they have to give you the permit. Period. No more discretionary rejections. No more bureaucratic gatekeeping dressed up in legal language. And the court gave states a 90-day window to bring their laws and procedures into compliance. That clock is already running. If your state is still operating under the old suitable cause framework after that deadline, you may have legal grounds to challenge the denial of your permit in federal court. This is a concrete, actionable change. Not theoretical, not abstract, real. If you applied for a concealed carry permit and were denied under a vague suitability standard, you need to speak to an attorney right now about whether your case can be reopened. The second major change goes after one of the ATF's most controversial enforcement tools, the classification of partially completed firearm receivers as regulated firearms. This is the so-called ghost gun regulatory framework that the ATF has been trying to enforce for years. Under the old standard, the ATF could classify an unfinished receiver, a block of metal or polymer that hadn't even been machined into a functioning firearm yet, as a regulated firearm under federal law. If agents determined it could be readily converted into a working gun, the problem was that readily converted was never defined. It was entirely subjective. An agent could look at a 50% complete receiver and decide that, in their estimation, it could be finished without too much trouble. And suddenly, you were in possession of an unregistered firearm. That's not law. That's bureaucratic opinion masquerading as law. The Supreme Court has now drawn a clear line. For something to be regulated as a firearm under federal law, it must be at least 80% complete, and there must be clear, objective guidance on how that percentage is calculated. That is a specific, measurable standard, not a feeling, not a judgment call, a standard. This matters enormously for hobbyists and homebuilders who work on firearms legally. It draws a boundary around what the government can regulate. And it holds. But the most powerful part of this change is that it is retroactive. If you were previously charged with possessing an unregistered firearm based on a receiver that would not meet the new 80% threshold, the court has ordered lower courts to review those cases. Charges that were filed under the old arbitrary standard may now need to be thrown out. That is not a small thing. That is the legal system acknowledging that it was wrong and being forced to correct the record. The third major change involves something that catches a staggering number of gun owners completely off guard every year. The line between occasionally selling firearms from your personal collection and being legally defined as someone who is engaged in the business of dealing firearms, across that line, even accidentally, and you're looking at federal felony charges for dealing without a federal firearms license. Before the Wilson ruling, the law was dangerously vague on where that line actually was. Some gun owners were prosecuted for selling as few as 5 firearms in a single year. Others sold 20 with no legal consequences whatsoever. There was no consistent rule, no clear threshold, just prosecutorial discretion, which is a polite way of saying that the law meant whatever the government wanted it to mean. On any given day, the court said that has to stop. There is now a defined threshold. You can sell up to 12 firearms per year from your personal collection without triggering the requirement for a federal firearms license. That is a number. That is a rule. And that is something a person can actually understand and plan around. But understand the critical distinction the court made here. The 12-gun threshold applies to genuine personal collection sales. If you are buying firearms with a specific intent to resell them for profit, you still need an FFL. Regardless of volume, the court is not legalizing unlicensed gun dealing. It is protecting the gun owner who occasionally sells a rifle to upgrade or clears a duplicate from their collection. That distinction matters. And if you engage in private sales, even legal ones, you should be keeping documentation, dated records, descriptions, serial numbers, the paper trail that proves your intent was personal, not commercial. Because in a federal investigation, the burden of proving your innocence falls on you, whether it should or not, and documentation is your first line of defense. If you are finding this breakdown valuable, and I know you are, because this is exactly the kind of information the mainstream media refuses to give you, then I need you to do something right now. Subscribe to this channel. Drop a comment below telling me which one of these 14 changes hit you hardest. This community exists because people like you refuse to stay uninformed. The comment section is where this conversation continues. Subscribe, comment, and stay locked in because we're only at change 4, and it's about to get more significant. The fourth major change goes after one of the most politically charged concepts in American gun law, the classification of firearms as assault weapons based on their physical features. For years, the ATF and various state legislatures used what's known as a features test to define and restrict certain semi-automatic rifles. The logic went like this. If a rifle had enough cosmetically aggressive characteristics, a pistol grip, an adjustable stock, a flash suppressor, it could be classified as an assault weapon and subjected to additional restrictions or outright bans. The court looked at that framework and called it exactly what it is, Arbitrary. A pistol grip does not change how a firearm functions. An adjustable stock does not make a semi-automatic rifle fire any faster. These features affect ergonomics and aesthetics. They do not change the mechanical operation of the weapon. The court ruled that ATF classifications must be based on the actual function of the firearm, not on how it looks to someone who doesn't like guns. This is a massive legal victory for owners of AR-15s, AK pattern rifles, and modern sporting rifles across the board. Features that were previously used as justification for restriction can no longer carry that regulatory weight. But the implications extend far beyond federal classification. The court's reasoning directly undermines the legal foundation of state-level assault weapon bans in California, New York, Illinois, and elsewhere, because those bans are built entirely on the same features test logic the court just called unconstitutional. The court did not directly strike down those state laws in this ruling, but they signaled in terms that cannot be misread that laws built on arbitrary features tests are legally vulnerable. Challenges to those state bans are already moving through the federal court system right now. Armed with the Wilson decision as precedent, those laws are on borrowed time. The fifth major change affects every gun owner who has ever driven across state lines with a firearm, which, if you live in the Northeast or travel frequently, means this change is directly relevant to your life. The Firearms Owners Protection Act contains what's called the Safe Passage provision, which is supposed to protect you when traveling through states where your legally owned firearm would otherwise be prohibited. The law said you were protected as long as the firearm was unloaded and stored in a locked container, and you were traveling from one state where it was legal to another state where it was also legal. In theory, that should have been simple. In practice, it was a nightmare. Law enforcement in states like New Jersey and New York were arresting travelers on the argument that they weren't directly passing through, that a stop for dinner, a hotel stay, a detour to a gas station somehow broke the protected journey and transformed a law-abiding traveler into a criminal. The court has now definitively clarified the safe passage provision. Reasonable stops, food, fuel, restrooms, and yes, overnight hotel stays are all protected under the law. The journey does not have to be nonstop. Life does not work that way, and the law cannot pretend otherwise. Equally important, the court shifted the burden of proof. Previously, you had to prove you were just passing through. Now, the state has to prove you weren't. That is a fundamental inversion of how this enforcement was operating. And it matters enormously. One caveat the court was explicit about: if you deviate from travel-related activities into something unrelated to your journey, visiting friends, sightseeing, extended stays that look less like travel and more like residency, you may lose the protection. The rule is, travel, stick to travel. The sixth change addresses the core technical issue that started the Wilson case in the first place: how the ATF measures the overall length of firearms to determine whether they fall under National Firearms Act restrictions. Before this ruling, the ATF's measurement methodology was inconsistent to a degree that should have been embarrassing. Folding stocks were sometimes included in the measurement, sometimes not. Muzzle devices were sometimes counted, sometimes ignored. The measurement was taken from different reference points depending on the agent. This is not complexity, this is chaos, and that chaos sent real people to federal court for possessing firearms that they had no reason to believe were regulated under the NFA. The court has established a single national standard. Measurements must be taken with the firearm in its most compact, operable configuration, from the rearmost point to the foremost permanently attached component. That's the rule. Now, one rule, consistent, applicable everywhere. If you have a firearm with a folding stock and the measurement taken with the stock folded puts it over 26 inches, it is not an NFA weapon under the new standard. If you have a permanently attached muzzle device, meaning pinned and welded, that device counts in the measurement. The ambiguity that destroyed James Wilson's life has been eliminated from the federal standard. The seventh change involves something called constructive possession, a legal theory that allowed the ATF to charge gun owners with possessing illegal firearm configurations that they had never actually assembled. Under the old standard, if you owned an AR pistol, and you also owned a rifle-length barrel that could theoretically be combined with it to create a short-barreled rifle, the government could argue you constructively possessed an unregistered SBR. Even if those two components had never touched each other in your home, that is a doctrine of presumed guilt. The court rejected it. To be charged with constructive possession of an illegal firearm configuration, the government must now prove that you actually intended to create that illegal configuration. Ownership of compatible parts is not enough. Intent must be demonstrated. This is a direct and substantial protection for AR pistol owners, for people who collect multiple platforms with overlapping components, and for anyone who is ever worried that the innocent accumulation of legal parts could somehow expose them to federal prosecution. The eighth change clarifies what knowingly means in the context of federal gun law violations, and it matters more than most people realize. Before this ruling, you could be charged with knowingly violating a gun law, even if you had no idea. The specific action you were taking was illegal. The government's position was that ignorance of the law is no defense. The court pushed back on how that principle was being applied to gun owners. Now, to sustain a conviction, the government must prove that you knew what you were doing was illegal, not just that you knew what you were doing. If you purchased a firearm without knowing you were a prohibited person because of a decades-old misdemeanor conviction that had faded from your memory, that is now a legitimate defense. The intent element has real teeth again. The ninth change raises the bar for justifying new gun restrictions under the public safety exception. Courts had been allowing gun regulations to survive legal challenges by invoking vague public safety rationales. Even when those regulations conflicted with Bruen and the Second Amendment's historical tradition requirement, the court made clear that a generalized appeal to public safety is not sufficient legal justification. Regulations must be narrowly tailored to address specific, documented safety concerns, and they must be grounded in America's historical tradition of firearm regulation. That is a significantly higher bar. It will make new gun control legislation much harder to sustain in federal court going forward. The 10th change hits the intersection of gun rights and marijuana use, an area that has been legally incoherent for years. Federal law prohibits gun ownership by anyone who is an unlawful user of a controlled substance. Marijuana remains a Schedule I controlled substance. Under federal law, regardless of what individual states have legalized, that created a situation where legal marijuana users in states like Colorado or California were technically prohibited from owning firearms under federal law, even if they had never been charged with any crime. The court narrowed that prohibition significantly. Only habitual, current users of illegal controlled substances are, now, prohibited. Occasional legal use in a state where marijuana is permitted does not automatically create a federal firearms prohibition under the new standard. This does not fully resolve the tension between state marijuana laws and federal gun laws. That contradiction runs deeper than one ruling can fix. But it does remove one of the most absurd applications of the prohibition, which treated a legal state activity as automatic grounds for stripping a constitutional right. The 11th change protects firearms collectors from being reclassified as unlicensed dealers. The ATF had been using the size and activity of private collections to argue that certain collectors were, effectively, operating as gun dealers without a license, even when those individuals were buying and selling solely to manage, upgrade, or refine their personal collections. The court drew a clear line. Collecting is not dealing, selling duplicates, upgrading components, trading within your collection. None of that constitutes being in the business of dealing firearms as long as the activity is genuinely collector-driven and not commercially oriented. The 12th change addresses the mental health prohibition on gun ownership. Before this ruling, any involuntary commitment to a mental health facility, including short-term emergency evaluation holds, could permanently strip a person of their Second Amendment rights. The court narrowed that. Temporary holds for evaluation are not the same as formal commitment. Only a court-ordered commitment, following due process, creates the prohibition under the new standard, and even lifetime bans based on historical mental health issues are now legally questionable under the court's reasoning. The 13th change narrows the definition of domestic violence for purposes of the federal gun prohibition. The prohibition now applies to violent or threatening offenses. Non-violent technical violations, like a non-threatening text message sent in violation of a protective order, no longer automatically trigger the firearms ban. The 14th change is perhaps the most personally significant for the largest number of people. If your state has a process for restoring civil rights after a conviction, and your rights have been restored under state law, federal law must now recognize that restoration for gun ownership purposes. For years, people whose state-level rights had been formally restored were still being denied firearms purchases. At the federal level, that gap has been closed. If you have an old conviction, if your state restored your rights, your path back to lawful gun ownership is now legally clearer than it has ever been. Here is what you do right now. First, if you have any firearms or components that existed in legal gray areas, AR pistols, partially completed receivers, firearms with measurements close to NFA thresholds, Document everything today. Dated photographs, measurements taken in writing, configuration records. Second, if you hold a concealed carry permit in a state that used subjective suitability standards, check whether your state has updated its procedures. If they haven't, and that 90-day compliance window closes, you may have the right to force the issue legally. Third, if any of these 14 changes touch a situation in your past, a denial, a charge, a prohibition, consult a qualified attorney immediately about whether your case can be reopened or revisited under the new standards. This is the biggest expansion of gun rights in decades, not a theoretical expansion, a real one, with real consequences for real people. The Wilson decision did what courts are supposed to do. It held the government to the standard of clear, consistent, constitutional law. It said that power exercised arbitrarily is not legitimate power, and it forced the most powerful enforcement agency in American gun law to follow actual rules. The media didn't cover it, the politicians didn't announce it, but it happened. It's real. And now you know, subscribe to this channel right now if you want to be the first to know when follow-up rulings, state compliance deadlines, and legal challenges develop from this decision. Share this with every gun owner you know. Their rights are affected by what the Supreme Court just ruled, whether they know it yet or not. This is David Hookstead. Stay informed.